It's good to have you back on the show.
Thanks for having me, Vicki.
So when I say it's bigger than Act 10, I'm talking about the structure of the decision. And that's what you're talking about in your piece. So without, making people's eyes bleed or ears bleed because it's confusing, I'm going to sum it up and you kind of, flesh this out. Basically, the judge blew off all of the ways judges typically approach questions of constitutionality of state legislation. They just blew it off. So the rational basis review kind of just blew it off, severing the problematic parts of a piece of legislation from the greater piece of legislation, just blew that off. And because of that, a whole bunch of different pieces of legislation are now potentially up for grabs.
Yeah, that's a great summary, Vicki, and I like that because I, as a lawyer, right, we always get the warning: don't get too far in the weeds. I'm going to use that. Can we at least let the weeds get up to our ankles?
Yes.
But no, that was a great summary of the decision, and I guess just taking a step back, I certainly am not minimizing the policy implications of what overturning Act 10 would mean. I mean, I've worked with local units of government really throughout my career. I've worked in a Senate office, Senator Strobel, that was always focused on ensuring we had efficient government. So I'm not trying to minimize that at all. I completely agree with our friends at McIver that easily the savings to local units of government since 2011 is easily in the billions upon billions of dollars. And one of the things I point out in my piece is if we go back to those pre-Act 10 days, people, I think, are missing a key point. We still have levy limits. And just today, right, everybody's touting the fact that the tax burden is now the lowest in history, right? Well, why is that? It's because of the reforms that were put in place during the Walker-Clayfish administration, and we have levy limits to ensure local units of government are not taxing beyond the means of their local property taxpayers.
Well, actually, they are. They're just using different ways to manipulate it. But yeah, the levy limits plus the exploding, uncontrollable, uncontainable costs that we had before Act 10 with collective bargaining agreements are going to very, very quickly render it unaffordable to live in Wisconsin because of property taxes. Your property taxes are expected to explode, and then, then they're going to ask you to keep voting yourself additional tax increases. But if you don't,
that's correct.
Go ahead.
That's correct. But I think it's also that I agree that they're going to find ways to increase taxes, to increase shared revenue. But in the meantime, if we have these levy limits in place and no longer the tools provided by Act 10, the dirty little secret is I think you're going to see some significant reductions in local government services and sadly, ironically, probably a significant number of layoffs of local employees for local units of government. So nobody's talking about it.
Well, and then the Democrats will just simply say we've got to get rid of the levy limits. But I want to talk about the process of this decision, because what I found troubling is that here's this judge in Dane County. And by the way, the majority on the Supreme Court has already politically campaigned saying that they want to overturn Act 10. Okay. So that's already, they're already on record as saying that, which is, again, makes this election for Brad Schimmel coming up so important to change the balance on the Wisconsin Supreme Court. But basically this judge said, well, we've got to look at rational basis review, right? But he didn't do it. So what's the rational reason why the state legislature has carved out this special place for public safety employees? And by the way, not just in Act 10, but in a whole different, a huge body of law in Wisconsin statute deals specifically with special considerations for public safety. Didn't even bother to take that into consideration. What might the legislature have been thinking rationally for exempting police and fire from Act 10? And then, if you decided you didn't care about that, why didn't, if he objected to the exemption of police and fire, just put police and fire under Act 10 instead? So he didn't bother to sever that little problematic piece that he found. He just decided to blow up the whole law.
Yeah, that's exactly right. And another good summary of kind of the key issues. So a statute in Wisconsin must meet 5 criteria in order to have a rational basis. And we quote this in our piece in American Habits, where Judge Frost himself emphasizes that, and I'm quoting here, we, the court, are obligated to locate or, in the alternative, construct a rationale that might have influenced the legislative determination. So in other words, even if it's not necessarily clear what the rational basis was from the legislature based on legislative history, legislative records, that a court, if they can identify a rational basis that kind of passes the test, they should rely on that. Because, right, and then let's take a step back. What's the whole point? The point is, and this really comes down to separation of powers, right? The courts interpret the laws. It's the legislature that makes the law. And then obviously the executive branch executes on those laws. And so this is a really, really fundamental principle that if a law can be saved, if there's any rational basis for a law to be saved, it should be. And so here, as you noted, Vicki, right, well let's take ourselves back to 2011. You have Governor Walker suggesting, proposing a really significant reform and that we all knew would cause a lot of labor unrest. And so basically there was an exemption carved out for active law enforcement personnel and jailers. Okay, that's a basis, right? We can't have jailers. I mean, you and I remember these conversations within policy circles. We can't have no jailers in our jails. That would be a problem. We can't have no jailers in our prisons. That would be a problem. And that's a rational basis for doing that. The other one is just that we have these 22 protective occupation participant categories. That's a lot, but basically under Chapter 227, there's these 22 categories. And the legislature said, look, we think these are, frankly, maybe more important. That's a policy decision. You can agree with that. You can disagree with that. I'm sure, for example, a DNR conservation warden may disagree that they're not as important or in as dangerous of a situation. And again, I would tend to disagree with that. I think if you're on the road at 3 a.m. in Milwaukee, you're in a lot tougher spot than a conservation warden. But be that as it may, right, that's a policy debate.
Right.
Let's have that debate. But that's not grounds for court overturning the decision by saying there is literally no rational basis at all.
Well, and then to say that there's none and then not defer to the legislature at all, even though the judge says, well, I'm sure I really should defer to the legislature, because the point here is you begin by saying we've got to figure out a way to keep the law, because we assume the legislature's intent in passing the law was constitutional and had a rational basis. This judge didn't do that. Said he was gonna, but didn't do that. So, and so when you look at the implications of this decision, just this one decision, it's catastrophic fiscally. By the way, it's another reason why Walker would have wanted Act 10. We had a $3 billion structural deficit that was solved by Act 10, which was originally called the Budget Repair Bill, by the way.
Correct.
But how does this now impact other reforms in Wisconsin? That's my concern, is that it's not just Act 10. It's anything else they have decided they don't like politically, drag it into Dane County Court. They somehow managed to keep the majority on the Wisconsin Supreme Court. And every reform they hate is now dragged before the Dane County justice system. Supreme Court takes it under original jurisdiction, and we're screwed.
Right. That is ultimately the problem here. As much as our courts are politicized, there still needs to be an actual basis for a legal challenge if you're attacking some statute. And the problem is this is essentially a roadmap, right? If you look at any of the other school choice, right? They clearly punted on school choice. There was litigation in 23. They didn't want to take it up because I think they're making political calculations. right to work, prevailing wage. I mean, just go down.
Go to old ones. Levy limits, school funding formulas. Sky's the limit here.
Well, and just yesterday, there was a major case argued, oral argument at the Supreme Court. Will was involved with that. Lucas Weber did an excellent job arguing that, relating to, I won't get into the weeds, but basically an administrative kind of rule decision relating to the ability of JCRER to review rules. I know you've had me on the podcast to talk about that. I mean, I know I'm an admin law nerd, and you're probably in that category, but you want to know an impact on every major project, every construction project, every DISPIS licensed job, huge impact on individuals. And so that's where Act 21, which is kind of the other major act from 2011 relating to administrative reform, I think that'll be at risk. So this is a roadmap to undermine, I think, a lot of the great reforms that occurred in 2011, 12, throughout the administration. And as you said, this is why this spring's election is so important. We have to put somebody back on this court that actually has a proper view on judicial interpretation and isn't concerned about their values. I mean, I do think 2023 was a watershed moment, and I know people have commented on the Kelly campaign. I know Dan, as a person, as a jurist, he laid out a clear vision for the court, and I think it was really an amazing moment in Wisconsin political history when we had a judicial candidate for Supreme Court justice she admitted that she was going to campaign on her values, not her judicial,
her political values, yes,
but her political.
Yes,
that's a watershed moment, and we have to turn this around.
Yeah, we failed that test in Wisconsin. We failed that test. Voter ID is at risk, which, by the way, is why there is going to be a voter ID amendment to the Constitution up for vote. But, I mean, all of these things, the Palm decision is at risk. You were talking about JCRAR. Someday we'll come back and we'll talk explicitly about why it is so important, the reform that took place for this really boring-sounding committee called the Joint Committee for the Review of Administrative Rules. I mean, it sounds dull, but it was very, very important to rein in, for instance, back in the day, the old Government Accountability Board, the DNR. Anyway, I'm out of time in this segment. Jake, I'm going to link your piece up so that people can find it really easily, but I do appreciate the time on the program today. Thank you.
Thank you, Vicki.
Jake Curtis, who is the general counsel for a wonderful group called Institute for Reforming Government. I will link this up to my Facebook page, and then I'll send it over to Brandon here so he can put it up on the blog as well. We'll take a quick break.